We are asked many times by our clients whether someone they are taking on should be treated as an employee or whether they should be classed as self-employed. The answer to this is not always straightforward, as there are a number of criteria that you should consider to determine the correct status of your worker. Getting it right is important, as it will affect not only the tax and national insurance liability, but other rights such as holiday and sick pay. Some of the easier criteria to check in order to determine a worker's status are the right of control. A self-employed worker will have the rights to determine how and where their work is carried out, whereas an employee would generally be told exactly where and when work must be completed. An employer is obliged to offer work, and the employee is obliged to do as requested. The opposite applies to a self-employed contractor, where if they are offered work, they are free to accept or turn down the offer. Neither is the employer obliged to provide the contractor with further work. A contractor will normally supply their own tools and equipment, whereas an employee will generally be provided with the tools they need to do their job. If you are self-employed, then you may quote on a job-by-job basis, and you may be able to make more profit if you're more efficient, or you may lose out if the job overruns. You may also be responsible for rectifying defects at your own time and at your own expense. Conversely, if you are an employee, you are paid in line with national minimum wage and you bear little risk of financial loss, unless your poor performance affects sales commission schemes or promotion or other benefits. There are many other factors to consider, and there isn't one particular factor that determines a worker's status. It is generally the picture as a whole that needs to be considered, as well as the motivations behind the relationship.